it again became abundantly clear that the defendant's curtailment of liberty, seizure, and unlawful detention and custody continued by this group of law enforcement personnel. No reasonable person would have believed that they were free to leave. This is all about Miranda rights and whether he had to have been read his Miranda rights earlier for them to use anything they got against him, whether it be physical evidence or anything he said to them.
Hey, it's Jordan. I am in Flint, Michigan, East Palestine, Ohio, Tumwa, Iowa. Please support the only independent outlet on the ground covering what the corporate media covers up.
Hey, it's Jordan with Status Coup. I know there's a whole lot going on in politics and it's quite chaotic, but I want to make sure you are updated on the ongoing Luigi Mangione case, the alleged shooter of United Healthcare CEO Brian Thompson. You have a lot going on here, including the Blair County, Pennsylvania prosecutors who are prosecuting him in Pennsylvania have requested a delay. They have requested to delay and basically get an extension on responding to Mangione's Pennsylvania attorney's explosive allegations that he filed in court on February 21st, essentially alleging that Luigi's arrest in Pennsylvania and seizure and inspection of his backpack and items was illegal, and thus asking a judge to suppress any evidence obtained from that arrest and seizing and detainment of his items, suppress it from evidence in any trial in Pennsylvania and possibly in New York. Before I get to that, let me show you if you are, someone who supports Mangione or his right to a fair trial. He has gotten a massive donation that is the biggest donation yet to his Give, Send, Go, which is the platform for his fundraiser. An anonymous donor contributed $30,000 to Luigi Mangione's defense fund, the largest donation the accused killer has received so far. I will show you, it's anonymous, but I can at least show you what the person wrote. Anonymous, this was 9 days ago. I never needed to worry about affording medical care, but I am here because even among the affluent, it is clear that from the motion to dismiss Adams' charges to the perp walk, the case is likely politicized. Makes me highly doubtful of any claimed evidence and pursuit of capital punishment. CP especially would personally and strongly tilt me in favor of defense. The motives are suspect and due process lacking. Hart number 2801. I don't know if that's the 2,801st person who's donated, but $30,000 is quite the generous donation to his defense, which his lawyers have already said they are accepting these donations. And obviously, this is from someone who is affluent and doesn't have to worry about paying for health care, but cares enough about everyone else and the fraudulent scheme. So the goal of the fundraiser is now $1 million. It was raised recently from $500,000 when that goal was reached, and they have raised $641,000 already, including that $30,000 donation. So let me give you the up-to-date information here. Yesterday in the Pennsylvania court, Blair County, the prosecution, the district attorney there, asked for an extension to respond to Luigi Mangione's attorney's motion. So Luigi Mangione's attorney, Thomas Dickey, he filed that motion that I reported on last week on February 21st, called a pretrial motion for relief, which was essentially to drop the case against Mangione, particularly to suppress any evidence that was seized. I'll put the link to my video detailing that 23-page court filing, and I'll give a little bit more details here. But that was filed on 21st of February. The court said the answer shall be filed not later than 10 days after the service of the motion. So yesterday was 10 days exactly, and the district attorney apparently in 10 days could not respond to the allegations. We could speculate. There's plenty of reasons that he might have not responded. I will give you my thoughts in a little while, but basically in 10 days, the district attorney could not respond to Luigi's attorney's motion, which tells me They have a lot they have to go through there in Blair County, Pennsylvania. For those of you that didn't see the video I did last week, this is the 23-page motion. I will put this link in the description also. Not going to read the whole thing again, but I'll give you what I think might be a major reason that the district attorney there asked for an extension. I think 10 days is probably enough time to respond to these serious allegations. Again, that essentially that his arrest was illegal, that he was illegally detained, that he was not read his Miranda rights when he should have. Let me read you what I think might be the reason for this request to delay the response in terms of the Pennsylvania district attorney. And this could affect the New York case as well, both the state of New York case as well as the federal case. The Altoona Police Department, this is where he was arrested in Pennsylvania, the Altoona Police Department took possession and control of identification materials presented by the defendant and continued retention of this material. Again, this is written by Mangione's Pennsylvania attorney, Thomas Dickey. The positioning of law enforcement officers, personnel, and the retention of a person's identification materials for a background check, evidence of criminal activity, and or investigative measures signal to a reasonable person that they are implicitly commanding the person to remain on scene while doing so. This is important in terms of Miranda rights, which I'll explain in a minute. At one point, Officer Detweiler walked outside the McDonald's while in possession of identification materials. During that brief interval, Officer Fry remained with the defendant within an arm's length and continued to curtail the liberty of the defendant, block his route, path of travel, ingress, egress, and movement from the dining table at McDonald's. It is clear that the Altoona police officer used the identification material and other information obtained via their interrogation for use as a background check and other investigative measures. The Altoona Police Department continued to interrogate the defendant. Within minutes, other members of the Altoona Police Department, both uniformed and plainclothes, arrived at the McDonald's. This resulted in the defendant path of travel from the dining table being blocked and prevented by two fully uniformed and armed Altoona police officers. Another fully uniformed and armed Altoona police officer remained on the other side of the dining table. Numerous officers, approximately 3 to 4, also blocked the path route of travel from the dining area in which defendant was seated to the service area of the McDonald's. Numerous officers also prevented the defendant from accessing the exit door from the McDonald's. An agent from the Pennsylvania Attorney General's office was also present. A member of the Altoona Police Department questioned the defendant and whether or not a backpack, plastic bag, and other items belonged to him. At that time, the Altoona police officer seized the items and packages and placed them in an area behind law enforcement personnel. To be clear, they did this without a search warrant. That's me adding that in. At all times, therefore, there remained Altoona police officers stationed between the defendant and the items of property believed to belong to the defendant. These items of property remained in control of Altoona police throughout. Defendant believes this action further supports his belief that he was not free to go. In order for the defendants to exit the dining table to venture to the service area of the McDonald's, he would have had to pass no less than approximately 7 to 10 members of the Altoona Police Department and or other law enforcement personnel. At this time, it is believed that there was an excess of 10 law enforcement personnel surrounding the defendant in the small dining area. It again became abundantly clear that the defendant's curtailment of liberty, seizure, and unlawful detention and custody continued by this group of law enforcement personnel. No reasonable person would have believed that they were free to leave. The curtailment of defendant's liberty and the detainment of the defendant at this time was in violation, in contravention of the Fourth Amendment. That's illegal search and seizure. 14th Amendment, that has to do with birthright citizenship, and Article 1, Section 8 of the Pennsylvania Constitution. And they go on to detail that in excess of 15 minutes had passed and the defendant's unlawful detention, seizure, curtailment of liberty, custody, interrogation continued. And then they detail that finally, after 15 minutes of the defendant's unlawful seizure and continued custody, he was advised by Officer Detweiler and he was officially under a police investigation. However, he was still not read his Miranda rights. It was only another 2 minutes that passed, so a total of 17 minutes that the defendant was read his Miranda rights. So let's break all this down. The purpose of this motion by Luigi Mangione's Pennsylvania attorney, and I'm not a lawyer, but I've looked into this. I've watched lawyers respond to this on their own YouTube channels, and I've read up on it. This is all about Miranda rights and whether he had to have been read his Miranda rights earlier for them to use anything they got against him, whether it be physical evidence or anything he said to them in an eventual trial in Pennsylvania. And it could be challenged in New York, both on the state and federal cases against him in New York. And this is all about, well, when do you have to read Miranda rights? Well, when is a Miranda warning required? Miranda rights come into play when two things happen. A suspect is, quote, in custody, arrested, or not free to leave. That's why throughout this motion, which again, I'll put the link in the description, it's very clear from, according to Thomas Dickey, that he was not free to leave and no reasonable person would have thought they were free to leave, or police want to question the suspect. In legal jargon, this is called custodial interrogation. Both parts must be true for Miranda to kick in. So this 23-page motion gives several times, I count 6 or 7 times, he detailed that he was not free to leave, i.e. he was being detained. He was in custody. Well, the prosecutor, the district attorney, had 10 days to respond to this. If this is all made up, which I'm assuming his attorney is not going to just file something completely out of thin air. Obviously, he's getting the information from Luigi Mangione to the best of his recollection, how it played out. I don't know if the attorney, Thomas Dickey, had access to the cameras in McDonald's. I doubt he had access to the police body cameras. But why, if you want to give the benefit of the doubt to the Pennsylvania district attorney, the Blair County district attorney, which I have a hard time doing, according to Dickey, so he's getting it from Luigi Mangione, and possibly if he had access to the McDonald's cameras, you're talking about 7 to 10 police officers that were there. Well, if you're the district attorney, you are going to want to have access to that all 10 officers' body camera footage to see, was he actually impeded from leaving, or is this attorney just, as they say, throwing spaghetti at the wall? Was he closed off? The attorney phrased it as there was a human wall of police officers and other officials around Mangione, basically making him, therefore, in custody. He was not free to leave. So you would think the district attorney wants to look at as much body camera footage as he can. Pure speculation, but to say in my first rodeo, as we know, let us know in the comments, police officers don't always have their body cameras on. So what if some of the body cameras were not on during that exchange in Altoona, Pennsylvania? Well, that's not going to be good for the prosecution because they obtained a whole lot of alleged evidence out from his backpack, including what they claim was a gun, 3D printed material for the gun. They claim they obtained the manifesto, but they searched and seized his backpack before issuing his Miranda rights. So I think it all comes down to the video evidence. The McDonald's cameras, I mean, the McDonald's is not the FBI. Maybe they have 1 camera, 2, but not from all angles. What's on those police body cams? That's what it comes down to. If there were really 10 officers there, I mean, I've covered a lot of police brutality. I've covered a lot of stories related to police. And I'd say half the time, not all police body cams are on. Even if it's 1 police officer, much less 10. So, devil's advocate, you say, well, Jordan, 10 days, if there's 10 police officers and this is really like a 20 to 30 minute period that they have to look through, the district attorney might need more time. But if they need more time, that would tell me the preliminary footage they look through. If the preliminary footage that you don't need 10 days to look through clearly debunks what Luigi Mangione's attorney is saying, you're not going to need 10 days, much more than 10 days to respond. You're going to respond right there. Yep. He had the ability to leave. And, they could have, even beyond Miranda rights, said that he could have filed a motion responding saying, somebody in the McDonald's said, this looks like the person for the wanted ads out there, and it was reasonable for us, within reason, to question him and ask for, preliminary questions like what's your name, where you're from, without reading his Miranda rights. So I'm not going to blow this up that it definitely means the prosecutors and the district attorney are in trouble or that the Pennsylvania cops truly fucked up. It remains to be seen. But I do think the fact that they are asking for a delay tells you there's some validity to Luigi Mangione's attorney's filing. I mean, that would just make sense. If it was completely bogus and he was just throwing spaghetti at the wall, you would think they would respond somewhat. Let me know if you have legal expertise in the comments if you disagree, but that's my reading of it. Also, this is just unbelievable. Remember, all of this, still alleged that Luigi Mangione did this, but all of this was over death care, health care, the for-profit predatory health insurance company, which United Health Care is the biggest of the predators. Well, after it recently came out that United Healthcare is under a civil investigation from the Department of Justice, DOJ investigating Medicare billing practices at United Health. That includes, because of actually credit to the Wall Street Journal, they've done great reporting on United Health's complete fraud when it comes to Medicare Advantage, which Brian Thompson was actively pushing that fraud. And the new CEO that replaced Brian Thompson was the head of their Medicare Advantage department. So they were, putting down fake diagnoses to get more money out of the government. They were making, increasing patient sickness scores, as they call it, all sorts of fraud. Well, that civil investigation by the DOJ, which does not go far enough, if you ask me, it should be criminal because this fraud actually kills people. United Health has responded. This is not an Onion headline. United Health to cut 10% of prior authorizations. Why, thank you. Thank you for cutting 10% of your fraudulent, should be illegal prior authorizations. United Health Group is taking another step to, quote, refine its prior authorization requirements as it continues to face public frustration. The healthcare giant's insurance business, United Healthcare, plans to cut nearly 10% of prior authorizations this year, the company said in a notice Saturday. As part of the initiative, the insurer said it will remove pre-approval requirements for home health services managed by its home and community division. The changes will apply to Medicare Advantage and dual special needs plans in 36 states and Washington, D.C. United Health did not immediately respond to questions about the type of health plans and procedures the broader prior authorization changes will affect. They represent the next step in our ongoing efforts to modernize the prior authorization process. No. Cutting 10% of a fraudulent, predatory, I think should be illegal. Middleman on top of middleman on top of middleman. I mean, it's something, but it's really nothing. This puts a Band-Aid on a gaping gunshot wound, which is the for-profit, predatory, denialist system that United Health is at the head of the table of. This needs there should be no prior authorizations, period. 10%, that's like somebody is drowning, dying of thirst in the desert, and I'm standing over them, hey, you want some of my piss? It'll refresh you. No, 10% cut, not going to do it. I will continue to report on this. If you are in New York and you want to go out to the next court hearing, that is scheduled for March 19th in the federal case against Luigi Mangione. So that's a little over 2 weeks from now. That will be March 19th, right outside the federal courthouse in downtown New York. We will be there like we've been to the other court hearings he has had. Thank you so much for your support. Thank you to all our new paying members. If you can support Status Coup, as far as I know, we're the only ones staying on this to this degree, not just particularly focused on Luigi Mangione's case, but exposing and following up on the predatory, murderous healthcare system. Please support us for as low as $5 a month. We really, really need to grow our paid membership if we're going to expand. StatusCoup.com/join. Support us for as low as $5 a month or 16 cents a day. That's what it comes out to. Have a great one.